Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, the first case we'll hear this morning is Myers versus Mayorkas. And Mr. Waller, we'll hear from you first.
Yes, Your Honor. Thank you, Your Honor. May it please the court, Shane Waller for the appellants Reba and David Myers. Your Honors, the question presented to the court is this. When the government seizes an innocent substitute asset for the purpose of forfeiture, does it also seize that property for the purpose of forfeiture under the Federal Tort Claims Act?
Just to get us off on both feet, that property was also seized under the criminal search warrant and was reported as being seized under it.
The government, Your Honor, the government maintains that it was seized under the criminal search warrant, but
it was on the return.
It is on the return, Your Honor.
Well, I just make that point. You can argue it, but the evidence that it was seized under the forfeiture is the same as the evidence that it was seized under the criminal warrant. And the cigarettes reported on both returns.
Your Honor, the property, that is correct. It was on the return for the criminal search warrant. The property, there was other property that was seized as a substitute asset, Your Honor. There was currency that was seized, money that was seized during the executions of the search warrant. That was also identified on the search warrant return, the Rule 41 evidentiary search warrant. And that property was also identified in a separate seizure warrant as an innocent substitute asset. Your Honor, a search warrant return is, there isn't any cause of an action for an error in a search warrant return. It's a magisterial function. And so to rely on the search warrant return as the legal basis for the seizure, I think causes difficulties, Your Honor. Well,
the warrant says to seize all the packaging. And so you seize the packaging and leave behind the cigarettes. That's a pretty strange idea. So if you're going to seize the cigarette packaging, the cigarettes go with it, and they reported it seized under the criminal warrant. Now that's just a fact in the record. They also reported it under the civil forfeiture warrant.
Your Honor, that assumes that the cigarettes, the cigarettes are the cigarettes in their packs, Your Honor. And so
who said that? I thought the warrant talked about cigarette packaging.
The warrant does. It talks about boxes, cartons, and tax stamps. And the evidentiary search warrant also describes the reason for taking tax stamps because sometimes there are counterfeit tax stamps at certain locations, and so they wanted those as evidence. And they're
on every package, right?
The tax stamps are correct. They're on this packaging, Your Honor.
So I want to make sure I understand what you're saying when we're talking about packaging. I mean, if you go in a convenience store and buy a box of cigarettes, are you talking about that as the packaging, or are you talking about broader packaging in which a number of specific boxes are contained?
Your Honor, I would suggest that that the government's packaging when it intended to seize it was the cardboard boxes that the cartons were in, the cartons that contain individual packs of cigarettes. And the government's intent in obtaining a seizure warrant for the purpose of forfeiture was then to take the individual cigarette packs because that is what has the value and that's what they could forfeit.
Where are the tax stamps? On what package?
The tax stamps are on the individual cigarette packages.
Okay, that's what they wanted under the criminal warrant. The packaging and the stamps. So the only way they could leave behind the cigarettes is if they opened every package and left the cigarettes behind and brought the packaging with the stamps.
Your Honor, I don't know that that's entirely clear because the evidentiary search warrant talks about contraband tax stamps. And so,
all right.
Yes, Your Honor. Your Honor, the difficulty here is that the government gained a tactical advantage in identifying this property as a substitute asset.
Well, maybe it did, but let's just talk about the test first. Yes, I mean, is it your position that the that the test that the district court used, the sole purpose test, is the appropriate test, and it's not satisfied, or do you advance some different test?
No, no, Your Honor. I would suggest that the Foster analysis, the sole purpose test, needs to be limited to the facts in Foster, Your Honor. That case is entirely factually different.
So what's the okay? So you say that's the test for Foster and it's limited to its facts. I mean, we can agree or disagree with that, but assume you're right. What's the test here? If we keep Foster to its facts, what do we apply here?
Your Honor, the test should be at the most basic level, the plain language of the statute. And the statute says if property is seized for the purpose of forfeiture, the government waives sovereign immunity.
So your position is if at the time of the seizure it had more than one purpose, it's the sovereign immunity is waived?
My position is that at the time of the seizure, Your Honor, it is the legal purpose, the legal basis for taking the property that.
Well, hypothetically, let's assume it said the package. Let's assume it said the cigarettes were on the search warrant. Okay. And the cigarettes are on the forfeiture warrant. You got undeniable dual purpose there, one of which is forfeiture, one of which is not. What happens there?
Your Honor,
under your theory?
Your Honor, under my theory, in that scenario, the government would have an independent legal basis to seize the cigarettes and hold them, Your Honor. The difficulty in not applying it in that way is because the way that CAFR is written and the way the statute reads is that there are rights inherent that become triggered based on how the property is seized.
Well, what do you do with the re-waiver provision that Congress enacted that creates an exception to your argument?
The re-waiver provision of the detention of goods exception, Your Honor?
Yes.
So under the detention of goods exception, there's 4 provisions, Your Honor. The first provision being that the property had to be seized for the purpose of forfeiture under any provision of federal law. But there's a second part to that as well, Your Honor, which is that the federal law has to provide for the forfeiture of property other than as a sentence imposed upon conviction of a criminal offense. The second paragraph is that the Congress is waiving sovereign immunity unless the interest of the forfeiture, the interest of the claimant was not forfeited. And then the third is that the interest of the complainant was not remitted or mitigated, and the fourth was that the complainant was not convicted of a crime for which the interest of the claimant in the property was subject to forfeiture. The reason that those are important, Your Honor, is because Congress was, not only were they waiving sovereign immunity, but they were retaining sovereign immunity in how they wrote that. And Congress was very specific in how that they wanted that immunity to be applied.
How do we apply the language of the warrant, the forfeiture warrant, where it says it's for forfeiture to remedy violations of the criminal code?
I'm sorry, Your Honor.
It says purpose of the forfeiture warrant. It says to remedy violations of Title 18 United States Code, Sections 2342 and 371, which is a conspiracy.
Yes, Your Honor.
So that it seems to me that that was the purpose of that forfeiture was to remedy a criminal violation.
Yes, they were attempting to address a criminal act.
Not address, it was for the purpose. That's what it says, the purpose.
Yes, Your Honor. But the underlying statutory basis for the forfeiture or for the seizure is what then triggers the other provisions of CAFR, Your Honor. In other words, Your Honor, if this property, because this property was seized as a substitute asset under the government did not need to perform a tracing analysis, which is required for civil forfeiture proceedings. The government could avoid that altogether. The government also didn't have to identify any sort
Well, the government, I agree with you. The government was trying to maximize the benefits of executing these warrants so that it didn't have to go one route or the other. But what I'm really doing is trying to follow up a little bit on Judge Quattlebaum's question is it looks to me like the government clearly wanted this to serve 2 purposes. One is the civil forfeiture and the other is to enforce the criminal laws.
Your Honor, the difficulty in the government's analysis and the test that
No, I'm looking at the evidence, not, let's forget the analysis. Let's look at the evidence in the case. I'm looking at the forfeiture warrant, and I'm looking at the criminal warrant. And the forfeiture warrant says it's for purposes of enforcing the criminal law, and both warrants report return of the cigarettes. So the government was very deliberate in executing the warrant for both criminal purposes and civil purposes.
Yes, Your Honor, but I would refer back to the detention of goods exception. The language specifically, it waives liability if it was seized for the purpose of forfeiture, but then it specifically retains sovereign immunity if three conditions are met. And so those conditions are that if it was not seized, if it was seized for the purpose of forfeiture, under any provision of federal law providing for the forfeiture of property other than as a sentence imposed upon conviction of a criminal offense. The property.
Well, that's the key I'm focusing on. It says other than for a remedy of conviction, but the civil forfeiture warrant, which you call the forfeiture warrant, says it's to remedy violations of the criminal violation. That's right in the text of it.
Yes, Your Honor. I agree that that is what the text says.
And doesn't that fall squarely in the waiver provision?
I would disagree, Your Honor, because the purpose of the seizure, the government expressly stated in its seizure warrant that it intended to take this property, to forfeit it, to take the money for it. And so it may have been trying to address a criminal violation, but all asset forfeiture, for the most part, is attempting to address some sort of wrongdoing, Your Honor. And so the plain language of the statute says if the purpose of the statute was forfeiture, then we're waiving liability unless it's as part of a sentence in a criminal case, or the person was convicted of a crime for which forfeiture was authorized, or the property was actually forfeited.
Well, I'm curious about where the Dollar Stretcher store in Winchester, was that where all the cigarettes were seized, or were there at other locations?
Yes, Your Honor. All the cigarettes in this case were seized there.
Well, what happens to the situation when the case is dismissed, as it was in this case?
And that's the difficulty, Your Honor, is once the case is dismissed, then what happens to the property? The property is now worthless because of the length of the time it took to get to a resolution in the case. And that's the exact issue that Congress was trying to remedy when it passed CAFR, Your Honor, was here's this property that's being taken, it sits in a warehouse somewhere, and it rots.
Sure, and it may be that, but the question is whether the situation Congress was trying to remedy is a situation where it's solely for substitute forfeiture purposes, or whether it's for those purposes and others. And I understand your argument that it wasn't for a dual purpose here. I mean, that's one argument. It sounds like you're really not going there. You're saying if there is dual purposes at the time of, if there are dual purposes at the time of seizure, the re-waiver doesn't apply.
Your Honor, that the court could reach that conclusion and we would still be successful here, because although the government generally said it was trying to remedy a criminal offense, the exact provision of the statute that it was relying on to seize the property was for civil forfeiture. The government affirmatively identified this property as a substitute asset, an innocent property, by its definition, unrelated to a criminal offense. So the government should be bound to that statements that it's making under oath and not be allowed to come back and, through the benefit of hindsight, to try to fit it
But
back.
they're not saying this. I mean, that may be true because the statute says, I think, at the time of seizure. So coming back after the fact and inventing another purpose, I might have some sympathy to the argument. But as I understand their argument, it's not that. It's that it was either an oversight. And to be fair, their argument shifted some. But that it was either an oversight or it was incidental to the packaging, and you really couldn't do anything else about it. So that's not coming in after the fact and changing it. That's saying at the time of the seizure, it was included, but for an oversight, it was included as incidental property.
Your Honor, that, whether or not it was incidental is a factual determination, and the government has offered nothing other than just the statements of government counsel.
I'm just trying to figure out, that may be right. That's an issue for discussion, but that would, I thought you were saying that even if those were true, you win because forfeiture was one of the purposes. And I'm just trying to understand your argument. I mean, if your argument is it's not really, they came in after the fact, or it's really only one here, that's one thing. But it seems like you're advocating a test that would, really make that this exemption, or really nullify the exception in large respects, because there's always some, or frequently some forfeiture element.
Your Honor, I see my time's expired. Would you
Yeah,
like me to
please
address
answer the question,
or-
sure.
I'm sorry, Your Honor.
You may answer the question, of course.
Yes, Your Honor. Your Honor, the appropriate test I would submit is the purpose of the forfeiture is the legal basis under which the property was seized. And in this case, it was no dual purpose because the forfeiture, the property was seized specific pursuant to the civil forfeiture statute for the purpose of substitute.
Let me ask you just to follow up, to get clear what your position is. Do you challenge the Foster case as an appropriate interpretation of the statute?
Your Honor, Foster was wrongly decided, Your Honor. Foster reads things into the
Do
statute.
you have a case going the other way?
Your Honor, there are no cases going the other way, and that's because there are no cases that have addressed the situation where the government seized property absent some legitimate.
I'm talking about the purpose where using the word solely. Foster said it had to be solely for the purpose. And the question is, and a couple of other circuits have adopted that. And so the question is, do you challenge that proposition, or is your challenge here that, in fact, it was not a dual purpose?
Your Honor, first, it was not a dual purpose, and secondly, in this case, in order to get to the Foster's holding, you have to add the word solely into the statute, which doesn't exist, Your Honor.
Well, it says for the purpose, and the question is, if it has multiple purposes, the question then is, can you rely on the one purpose that falls within the sovereign immunity? And that's what Foster did, because we read sovereign immunity restrictively. And you challenge that too.
Your Honor,
You say Foster was wrongly decided.
yes, Your Honor, Foster was wrongly decided because
Okay.
it adds solely to adding words to the statute, Your Honor.
Okay, thank you. Yeah, we'll have you back on rebuttal. All right, Ms. Taylor?
Yes, good morning, Your Honors. Laura Taylor on behalf of the United States. I appreciate your time today. It is plaintiff's burden to prove subject matter jurisdiction, and he has not met that burden here. We would ask,
Well, that's the issue.
well, it's his burden to prove it, and he must allege it in his complaint. And here we would ask the court to affirm the district court's dismissal of the Myers complaint because the cigarettes were in fact seized for the dual purpose of evidence in a criminal investigation as well as forfeiture. And therefore, the United States has retained its sovereign immunity under the FTCA.
So assume, counsel, we agree with you that the dual purpose or sole purpose test, I don't know what you call it, but that the Foster test applies. Is it the government's position that there was oversight in the drafting of the Rule 41 warrant? Or is it the government's position that the actual cigarettes are incidental, inherent in what was included in the warrant? What's y'all's exact position?
The short answer, Your Honor, is both in a waterfall argument. I think the government would concede that it intended to include cigarettes as a specific item to be seized in Attachment B to the Rule 41 warrant.
Okay,
and it
let's
was an
stop on
oversight
that.
Not to include that.
Let's deal with that one first, that you intended to do it. Where's the evidence you intended to do it?
So there was not evidence of that fact in the form of an affidavit provided to the district court that's in the record in this case.
Okay,
That
so
has not
that-
yet been established.
Okay, so, all right, so, I'm sorry,
Oh,
go
sorry,
ahead.
Your Honor. I
No,
did
you
not
can
mean to
finish.
interrupt.
I didn't mean to, I want you to have a chance to answer.
So there's not direct testimonial evidence from the agent that that was his intent, but there is certainly circumstantial evidence as provided in the record reflected in the fact that the cigarettes were seized and documented in the return to the Rule 41 warrant. Now, all 4 pallets of cigarettes are detailed explicitly in the Rule 41 return.
But do you have a problem there? Because, I mean, I hear you. I mean, I think there's evidence in the return that would be consistent that they were intended. You know, I think you could read the Lamboni affidavit both ways. I mean, the fact that it was changed could have meant that it was intended all along, or it could have been something changed after the fact. But I have a little bit of a concern that, people don't always get it exactly right. I mean, oversights happen, but if that's a position, that's an evidentiary position. It's not contained in the complaint, and so I'm having a little concern how you get there in a Rule 12 context.
Yes, Your Honor. The way you get there is because it's not dispositive of the issue. Judge Dillon correctly held that law enforcement would have had authority under Rule 41 to seize the cigarettes incidental to seizing the packaging anyway.
So
the oversight becomes irrelevant.
So then you go to the incidental argument. Is that right? Does that require? Is that something that's just self-apparent? Does that require evidence?
No, Your Honor, it does not. And that is the most streamlined way to resolve this case. That because
Why did y'all say? Why did y'all first say it was an oversight?
Your Honor, I believe both to be true. That it was an oversight that cigarettes were not explicitly enumerated in Attachment B, but that they were then lawfully and properly seized as incidental to the cigarette packaging. So if we were here, for example, on a motion to suppress in the criminal context, the question would be, does Attachment B allow law enforcement to have seized the cigarettes incidental to the packaging? And Judge Dillon's answering that question in the affirmative, that she's finding, yes, it's incidental. So regardless of whether the cigarettes should have separately been enumerated in Attachment B becomes irrelevant at this point. And of course, whether or not the evidence would have been subject to suppression is not the relevant question. The question is, what was the law enforcement officer's intent at the time of initial seizure? And that intent is proven both by the Rule 41 return, as well as the fact that there is a common sense understanding that if you're seizing the packaging, you would be seizing the cigarettes. You would not take the cigarettes out of its packaging because to do so would destroy the value of the
It
cigarettes.
just seems odd that I think did the government submit the Lamboni affidavit?
Yes, Your Honor.
But if you're sitting here, if you're arguing that the intent of the officer is what's important, and you didn't put that intent into evidence, I mean, I think if you had put that intent into evidence, it would be hard to disagree with that. And I'm not fussing the lawyers. Being a lawyer's hard. I know. That's not being critical. It's just we're here in a 12B context, and you're saying the key thing is intent, and yet you put in an affidavit, but not the one that would show that intent.
Yes, Your Honor. And I did not, I was not the line AUSA who handled this below, and I asked the same question when I began my preparation for this appeal, because that seems like it would have put an end to all of this question here that we are talking about today.
What happens to the fact, or does it make any difference, that all the cigarettes seized were from Winchester, and that case ended up getting dismissed, and she's found not guilty?
Yes, I would.
So why do you sit on the cigarettes for, 4 years, 5 years?
Judge Floyd, if I understand your question correctly, you're asking about what impact the acquittal had on the continued detention of the cigarettes.
Yes.
And here the timeline is important, and I'd like to answer that question and then follow up a little bit on Judge Quattlebaum's question as well. So the search warrants here were executed in 2015. That was the time of seizure. The indictment and criminal trial didn't take place for several years later. After Ms. Myers was acquitted in her criminal case, The government then offered to return the cigarettes, and she declined. So it was not 4 or 5 years after the acquittal that the government held on to the cigarettes. It's that the indictment and criminal trial took place several years after the seizure. So the evidence
The
had
life
been
of the
maintained
cigarettes
by
is
the
less
government.
than a year, or a year roughly?
The complaint alleges that the shelf life of the cigarettes is approximately 12 months. And if I could just revert.
So the cigarettes went stale before there was even an indictment?
Yes, Your Honor.
Well, don't you have a duty to take care of the property that you seized?
When the government seizes evidence for purposes of a criminal prosecution, there is sometimes the risk that that value of that evidence will diminish during the government's possession. That's why Rule 41G exists in the Federal Rules of Criminal Procedure to allow a criminal defendant to seek the return of his or her property if there is a risk of the loss of value or damage pending the criminal case. Here, Ms. Myers never filed a Rule 41G motion, despite being made aware that the cigarettes had been seized pursuant to the Rule 41 search warrant by receiving a copy of the inventory return. So she could have sought that redress through a Rule 41G motion, and she chose not to. So yes, there's a chance at times that evidence could lose its value pending a criminal prosecution, and the defendant has an opportunity to address that by filing a Rule 41G.
Well, that gets to the whole damages in this case, though. It looks to me like Congress intended that that kind of damage was not waived, and that there's sovereign immunity as to that kind of damage.
That's correct, Your Honor. That's exactly right. The longstanding position of Congress through the FTCA is that the government retains sovereign immunity regarding the detention of goods for purposes of a criminal prosecution, which is exactly what we had here. And then to revisit Judge Quattlebaum's question briefly, if I may, Your Honor, at this juncture, it is the plaintiff's burden to allege in the complaint facts that can plausibly allege that the sole basis of the seizure was forfeiture. Here in the complaint, the plaintiff explicitly concedes that the seizure was done as part of a law enforcement action that resulted in a criminal prosecution, albeit an acquittal, but still went to trial.
Yeah,
And
I think what they alleged, I mean, you're right, it was in the criminal context. So, I mean, if your argument is every time it's in a seizure for forfeiture purposes that has some connection with the criminal, with a criminal case, that's a pretty broad reading of the thing. I think what the plaintiffs say is, look, we got 2 warrants. One of them has cigarettes in it. It says forfeiture. One of it doesn't. It says Rule 41 seizure. You know, why doesn't that meet their basic burden? And then it should, and then the government needs to say, oh, no, that may be what it says, but it was either oversight or incidental. And I think you could do it. I mean, apparently there's someone around who had that intent. I think, you know, if it has dual purposes at the time of seizure, you know, the text, it supports the Foster analysis. Or, yeah, at least that's what, but yeah, anyway, I may be beating a dead horse with you. I'm concerned that you're talking about intent that, you know, at least could be inconsistent with the documents. It could be consistent with the documents. So that's my problem.
I understand, Your Honor. I would point Your Honor to the smoke shop case out of the Seventh Circuit, as well as the District of Maryland's decision in Star Indemnity, because in both of those cases, there was a finding that the plaintiff's allegations themselves fell short, because the plaintiff's complaint admitted that the items were seized as part of a criminal investigation in addition to the purpose of forfeiture.
But what if it's, I mean, you know, what if here there's a, you know, arguably kind of close connection. I mean, it's about cigarettes. These are the cigarettes. But, I mean, you know, what if it's more removed than that? I mean, you took some other assets from the store that didn't have anything to do with the cigarettes, and then the same sort of, you just say, yeah, it was all part of a criminal thing. I grabbed all the liquor too.
Sure. So there are certainly hypothetical examples where the dual purpose may be less clear and may require more evidentiary proof or more discovery, but that's just not this case. This case didn't rise to the level of needing an evidentiary hearing because on the
Why does it, let's talk about this case. Your theory under the warrants are that what was going on is that they were selling these goods to people who either came in from New York or were headed to New York to sell the cigarettes. I thought this for a while was like you didn't pay the taxes on it. But it sounds like it's not that. It's that, the taxes are higher in New York, so people were getting these cigarettes in Virginia. This was the theory, and taking them up to New York where they could make a bigger profit. So, I mean, what evidentiary value do the cigarettes even have?
You are correct that the government's theory was kind of a quintessential cigarette trafficking theory where you purchase cigarettes in a state with lower taxes, with valid tax stamps in that state, and then you sell them on the secondary market in a state with higher taxes because you can make money on the secondary market selling it that way, and even though it's obviously illegal because you're selling cigarettes from the other state with their tax stamps on them.
It's not illegal necessarily. I would think it's not illegal to sell them unless you are aware it's part of some trafficking conspiracy. And I know that's the theory.
And in addition, Ms. Myers was also charged with record-keeping violations, that when you are a retailer of more than a certain number of packages of cigarettes, you must maintain certain records that the government can then inspect or be produced to show that you are a lawful and proper retailer of cigarettes. So it's my understanding she was charged both with I have this correct, the conspiracy to traffic illegally in cigarettes as well as the record-keeping violations. And of course, she also pled to the tax evasion charge. So there was a multitude of
But from the actual trafficking count, the cigarettes and quite frankly, the packaging seems fairly irrelevant. I mean, the packaging looks just like any other packaging that's going to be sold in Virginia. I mean, the evidence, it seems to me, is the evidence of the purchasers.
The best evidence would be you have evidence of the purchasers selling the cigarettes in New York and you match it to the cigarettes that are being sold in Virginia so that you can prove that Ms. Myers is the co-conspirator in Virginia who's allowing the trafficking to happen.
What was the theory in
New
this
York.
case? Did they leave the Virginia tax stamps on the packages and put on fake New York ones, or what did they do?
And Your Honor, please excuse me, this case was prosecuted out of the Northern District of West Virginia. Because the forfeiture was in our district, we handled the forfeiture side, not the criminal prosecution side. So I am not 100% certain of the answer to your question, but I believe the answer is yes, that they would leave the stamps on. But I can confirm that and provide that in a supplemental.
Oh, that's all right. I would think the stamps would be relevant.
Yes.
And the affidavit shows the statutory definition of cigarette includes packaging, and packaging includes cigarettes, and it's in the disjunctive.
Yes, Your Honor, that's exactly right. And I'd also be happy to provide supplemental briefing on the record-keeping charge, but to the extent that one must prove that the retailer had a certain number of qualifying cigarettes in the shop in order to then trigger the record-keeping violations, the cigarettes and the volume of those cigarettes would be essential proof at trial on that element. But again, because my office did not prosecute the criminal case, I lack 100% certainty on this, and I would prefer to provide it to you in a supplemental brief if it's critical.
And I don't need that for this purpose. Thank you.
In the smoke shop case out of the Seventh Circuit, the court emphasized that if the allegations give rise to a plausible alternative explanation, like a criminal investigation, then the government retains its sovereign immunity.
Well, I assume that you're saying the government is one thing. The criminal prosecution occurred in West Virginia, and your forfeiture here is in Virginia. How is there a dual purpose then? Your sole purpose was forfeiture.
Well, in the broad sense, Your Honor, the government acts as one. Here, it was a joint task force that applied for simultaneously Rule 41 warrants as well as forfeiture warrants. By operation of law, the Rule 41 warrant must be issued in the district where the property is located, whereas the forfeiture warrant may be issued in the district where the forfeiture will be pursued. In this case, the Northern District of West Virginia was the primary prosecuting jurisdiction. And much of the
So for
criminal
venue
activity-
purposes, she lived in in West Virginia, right?
and much of the criminal activity took place there, but the store itself was located in Virginia. And so this was a case where the criminal activity crossed state lines, and when the law enforcement officers sought to execute the search warrant at Dollar Stretcher, that was in our district in Virginia, and so they coordinated with our office to apply for the Rule 41 warrant from one of our judges. But the case was a West Virginia case, not a Virginia case in terms of the prosecution of the Myers.
Anything else?
If the court does not have any further questions, I'm happy to rest on my briefing, and I'm happy to revisit the question, Judge Quattlebaum, you asked regarding the charges in the indictment by supplemental briefing. If you would like, please just let me know.
You mean about the record keeping issue?
Yes, Your Honor.
No,
Because I'm not certain about that, I would be happy to provide it subsequently.
Okay, thank you.
All right, Mr. Waller?
Your Honor, the fraud scheme alleged in the search warrant and the seizure warrants, and what Ms. Meyer was charged against Ms. Myers was record-keeping violations. There was no allegation that they were using contraband tax stamps. There was allegations that they were not recording transactions of over $10,000, and they were not recording cigarette sales of over a certain quantity, Your Honor, which does make the evidentiary value of these cigarettes quite questionable. And considering where we're at, I think the court has hit on this, considering where we're at in this process, it's difficult to look on the one hand of the clear statement of the government's purpose in a document it's submitting to the court under oath, that it's going to take this for the purpose of forfeiture. It then takes the property and logs it in as non-evidence forfeitable property in its tracking system. And so at least for a 60-day period of time, the government is holding this property by its own admission as nothing other than forfeitable property. And there potentially is a period of time where some or all of those cigarettes may have perished, since this is a perishable good. So there's at least a 60-day window. And then at some point when the government decides to change the internal categorization, the document, the affidavit the government submits is just a hearsay document of, respectfully, a paralegal who's assigned to track the property that says just kind of vaguely that I was told to do this. It doesn't say why she was told to do this or that the government affirmatively identified it as evidence. And the property they're in is that at this early junction, without any sort of declaration or affidavit from the agents in this case as to what their intent was, how does the court reach the factual determination that it was in fact for a secondary purpose? The only thing supporting it is the fact that it was included on the return, but it was also included on the return for the seizure warrant.
What about the incidental issue? I mean, the incidental is self-apparent. I mean, let's assume that they were after the packaging, and not necessarily the contraband, which is one. I mean, I know they said both, so that you could come back with me on that. But I mean, the incidental issue. Do we really need evidence for that? I mean, they're in. The stamps are on the cartons. I mean, you know that it seems to me, the good faith intent is one thing, but the incidental issue is just a matter of kind of common sense. In fact, I'm wondering whether we need more evidence for that. That's what the district court ultimately relies on, right?
Yes, Your Honor, and I would submit that the court does need more information in the face of the government explicitly categorizing the evidence as the property as non-evidence forfeitable property.
What do you do about the fact that they never offered the cigarettes into evidence?
I'm sorry, Your Honor.
What do you do about the fact that the government never offered into evidence the cigarette pack itself?
And Your Honor, I think that the fact that they didn't use it as evidence, that they didn't offer the photographs as evidence, that they didn't include it on its witness list, or on its exhibit list, all demonstrates that the government didn't view it as evidence. And so, for the government counsel now to say it was evidence, I think...
Is a subjective intent standard applicable here? I thought it was an objective standard on what the searches were and so forth. I mean, if an officer had subjective intent to punish somebody, is that relevant? by executing a warrant? In other words, we're under a standard that's an objective standard of seizures and searches.
Yes, Your Honor, and I would respectfully.
So regardless of what they thought and what they did and how they used it, doesn't matter. The question is, was it seized legally? Both of them. And what was it seized for? And the question is, was it seized for dual purposes? You say it wasn't, but that's a question that can be determined objectively from the record. And then the question is, if it's seized jointly, then that's a legal question. Does the Foster opinion apply, or is a Foster opinion wrongly decided, as you argue?
Yes, Your Honor.
I think that's what's before us.
Yes, and the difficulty with the test that the government is asking the court to adopt is this. The government is essentially saying that its accusation of criminal wrongdoing removes the government from liability under the Federal Tort Claims Act.
Well, you have to read the Federal Tort Claims Act, and the one exception there says for criminal prosecution, isn't it, or something like that, to that effect, a detention for criminal prosecution?
Your Honor, my time's expired, may I?
Yes, of course.
Your Honor, and the exception is not for criminal prosecution.
What's the language? I'm trying to.
It's okay, Your Honor. I apologize. I didn't mean to.
Yeah, no, I'd like to just know what the language of the Tort Claims Act's exception, that number one.
Yes, Your Honor. Your Honor,
Very end of the sentence.
Congress, under the detention of goods exception, the Congress specifically retains sovereign immunity if the property was not forfeited as part of a criminal sentence, or the individual was convicted under a statute that allowed for forfeiture, or if the property was forfeited. So the statute clearly retains immunity for specific situations, Your Honor. Thank you, Your Honor.
Okay, thank you. All right, I think we're still under protocols of COVID. We're operating under those. I see you all have masks. It's good to see. And our normal practice would be come down and shake your hands. This is unique to the Fourth Circuit, and we've always treasured that idea. This whole exchange is a civilized exchange. We don't have dueling in the courtrooms and so forth. So we confirm that with our handshakes, and we'll retain that practice, but we're not doing it during the COVID protocols. But we do want to thank you for your arguments, and we virtually shake hands from the bench with you. Thank you very much, and we'll proceed on to the next case. Anago versus Garland, and Ms. Velasquez, we'll hear from you first.
Good morning, Your Honors. May it please the Court, Elsie Ramos Velasquez on behalf of the petitioner, Beatriz Nuecheng Anago. The issue here is whether the Board of Immigration Appeals abused its discretion when it determined that Ms. Anago did not demonstrate a material change in country conditions to warrant reopening under the time limit and number limit exception under the regulations. We determined that she did meet those exceptions, and the reason why is because the country condition evidence submitted by Ms. Anago is material and it is relevant to the current conditions in Cameroon. The evidence submitted demonstrates that it was not available back during her initial proceedings in the early 2000s. When Ms. Anago submitted her motion to reopen, it was in 2019 after a rise in armed conflicts in Cameroon.
Well, the government makes the argument that this evidence is just incremental and not material. And what do you do about that argument?
Your Honor, we disagree with that argument. And the reason is because while there have been political protests and political opponents have been arrested, detained, and that did happen in the early 2000s when Ms. Inago applied for asylum, we now see an increase and a complete change in how the Cameroonian government is handling protesters, specifically those from the Anglophone region. Under the current conditions, starting in late 2016 and in early 2017, we see a complete change in the Cameroonian government's attacks on the Anglophone regions, which are in the northwest and southwest regions of Cameroon. Now that those Anglophone regions are under complete military control, we're seeing armed conflict between government forces and the separatist groups that are located in those regions. Civilians are being attacked. The president of Cameroon has even designated all Anglophones to be considered a threat to the Cameroonian government. This is completely different than what we saw in the early 2000s, where SCNC supporters and advocates and protesters who were moving forward to try and separate from Cameroon were arrested. They were detained, but they were usually released after a few days or a few hours without any charges. We do see back in the early 2000s where individuals were also tortured while in detention, but we don't see the armed conflict that we see now and what is happening currently in Cameroon, where the government forces are going into these Anglophone regions and attacking not only the separatist groups, but also civilians. And for that reason, we do see and we do believe that this is a material change. It's not something that has just over time progressed. It started in late 2016 and it developed in early 2017, and it completely erupted between 2017 and 2019 into a full-on armed conflict between Cameroonian government forces and separatist groups in the Anglophone regions.
Counsel, can I follow up on something you just said? It seems to me we got one issue when you when we categorize the claim of your client that there's persecution on account of her participation in the group SCNC, the separatist group, and we have this issue that Judge Floyd talked about. You know, there was stuff before. There's maybe more severe. Did the board abuse its discretion in terms of the change of country conditions? I have that issue kind of on the one hand, but your client also said that there was persecution on account of being an Anglophone, in addition to being a SCNC separatist. And it didn't look like you briefed that argument to us. There was no discussion of the board erring by not addressing the Anglophone group. Was there a reason? I mean, is there something about that argument that is, you know, less compelling? I was surprised. I just wondered about that issue and didn't see it in the briefs.
No, Your Honor. Your Honor. And when we look at the NCNC current conditions, NCNC is advocating for a secession of the Anglophone regions. So when we look at what's going on with NCNC, we think about also the Anglophone regions, and so they're combined. And so now what we're seeing is that when country reports are addressing the current conditions in Cameroon, they're using the Anglophone crisis. That's how they're addressing it. But when we read those reports...
Could you repeat what you just said again?
The Anglophone crisis.
Okay.
And specifically, when we think of the Anglophone crisis, we immediately think of the SCNC, because in the late 1990s, early 2000s, NCNC was the organization that was moving for the separation. They were advocating for Anglophones. And so we didn't present a separate argument for Anglophones because we believe it's included in our SCNC argument.
Okay.
And we see that when we look at country reports, we see the mention of the NCNC moving forward and trying to create their own country apart from Cameroon. And for that reason now, Anglophones are being included in that group with them. And the government is prosecuting and is persecuting not only SCNC members, but the entire region as a whole. And Anglophones are seen to be associated with these separatist groups that are moving for separation from Cameroon. And we see that in not just only the Department of State reports, but we see it in the expert report submitted by Dr. Walker Saeed. We also see that in the Human Rights Watch report. There are several articles from Human Rights Watch that have gone on and have demonstrated that this isn't just a rise of political prosecution or political persecution where protesters and advocates are being arrested and detained. We're now seeing individuals being arrested, detained. We're seeing villages burned down, homes burned down, and armed conflict, live ammunition being used against demonstrators and protesters. This is much more than just arresting a protester for demonstrating for an illegal organization. This is an armed conflict that is being moved forward by the Cameroonian government, completely different than the conditions that we saw in the late 1990s and early 2000s. And for that reason is why we believe that there have been a material change in circumstances and that these new reports are relevant to demonstrate that Ms. Anago does warrant reopening because of these conditions. And when we look at the case from the Fourth Circuit, Ranrong Lin versus Holder, we look at that case, and in that case, that was a Chinese family planning case. And the court there established that there were no country condition changes that warranted reopening, but the reason why is because the evidence was not relevant. The evidence had been previously submitted. Also, there was evidence that was not authenticated, and there was evidence that didn't even apply to the circumstances of the petitioner. That's completely the opposite of what is going on in Ms. Anago's case. All of the evidence that we submitted with the motion to reopen directly relates to the conditions in Cameroon and how she is impacted not only as an SCNC member, but as an individual who identifies as an Anglophone.
Well, if we accept your argument, shouldn't the BIA in the first instance get an opportunity to consider, again, those factors you just outlined?
Yes, Your Honor.
You're not asking us to make the decision.
No, Your Honor. We're requesting for the case to be remanded in order for the country conditions to be properly considered to allow Ms. Anago to seek asylum. We're not asking, the court to grant Ms. Anago asylum. We're asking her to give her the opportunity to provide her claim for asylum based on these changed country conditions because they have drastically changed since she applied in the early 2000s.
Well, did the board make any initial determination as to whether Anago established a prima facie case for eligibility for asylum?
The board didn't reach that conclusion. The board did address...
Did or did not?
Did not. The board did address the previous adverse credibility claim, but took her current statements under the current motion to reopen as true, that she's a member of SCNC and that she identifies as Anglophone. And based on that, the next step was to determine, are there changed country conditions? And that's where the analysis ended. The board held that the conditions didn't change, that there was just an incremental change. But we disagree because what we saw in the early 2000s was country condition evidence that demonstrated this was just a political movement, political protesters and advocates were being targeted, they were being harmed, but now this is now a larger scale force.
How long do we keep doing this? Can she come back in 20 years and say there's another change and try to reopen? I mean, when was the order issued in this? 2007, 2009?
2008, she was issued an order of removal. She did appeal that to the Board of Immigration Appeals. Her appeal was dismissed. A few years later, she filed a motion to reopen based on completely different facts that she was eligible for adjustment of status.
So isn't there a statute of limitations in this?
No, Your Honor. The regulation provides...
No, forget the regulation. I'm focusing on the statute. What does the statute say?
So the statute indicates that there are time limitations and number limitations.
Right.
However, if there are changed country conditions that are material and relevant, an individual can present a motion to reopen based on those country conditions. It's an exception that's listed in the statute.
Just for number, isn't it?
It's for time limits and time limit limitations.
In the statute?
In the limits, yes. It's under INA 240C7C2. While it indicates there is no time limit on filing of a motion to reopen if the basis of the motion to reopen is to apply for relief under Section 1158 of this title, and it is based on changed country conditions arising in the country of nationality.
What's the number? Is it a number? Is there a limit on the number?
No, there is a limit you can apply. Normally, when you file a motion to reopen, it must be...
I'll tell you what I'm getting at is the statute does not make an exception with respect to one of those. I don't have that before me. And the Fifth Circuit noted that. The regulation does make an exception. and it gratuitously adds one of them, which is not provided in the statute. The Fifth Circuit says that's inconsistent with the statute. And I was going to ask you what your thoughts on that were.
So when it comes to,
This is the DJ case out of the Fifth Circuit.
thank you, Your Honor. Yes, the statute addresses time number limitations. It doesn't address how many motions to reopen an individual can file. And so because it leaves it open, we believe that if the country conditions change in 20 years and she now has a claim for asylum, Ms. Anago should be allowed to seek reopening of her removal proceedings to apply for asylum. And then the board...
Is there an exception to the 2 petition limit?
No, there is no exception, Your Honor. There are no...
Well, then why did you filed your 2 petitions? Why isn't that now barred?
So, and the reason is because this individual is seeking asylum. And so because she's seeking asylum, there are exceptions to the statute, in the statute. Because an individual who's seeking asylum is fleeing persecution, and because of that application for asylum...
Well, I'm sorry, I'm not getting my question across. If I understand the statute, it makes an exception for either the time limit or the number, but not both. Whereas the regulation makes an exception for both. Do you understand what I'm saying?
Yes, I understand, Your Honor.
Okay, now my question is, do you have any exception? I don't know whether it's the time limit or the number under the statute where it doesn't provide an exception.
Not at the moment, Your Honor, and I can definitely supply that in additional briefing if the court would like. But from our reading of the statute and our reading of the regulations, Ms. Anago's first motion to reopen was not based on asylum. This second motion to reopen is based on changed country conditions that developed in late 2016 and increased in early 2017. And by 2019, when she submitted her motion to reopen, based on these country conditions, there was a full-on armed conflict that warrants, and this is why her case warrants reopening, because she is seeking asylum based on these changed conditions. The conditions that were in place in early 2000s are completely different to what we see now. There has been an increase. There's like I mentioned before, now we see an armed conflict. These are new facts as to what's going on in Cameroon at the moment when it comes to NCNC members and advocates. And for that reason is why we believe that this case should be remanded to allow the board and the immigration judge to review and determine if Ms. Anago is eligible for asylum based on these changes. And we see that in all of the reports that were submitted with Ms. Anago's claim. In the initial filing, when Ms. Anago applied for asylum, most of the country condition evidence did address the human rights concerns that were going on in Cameroon, where people were being arrested, they were being detained. But what we see now, and while yes, the current conditions also mention protesters being arrested and being detained, we also see how the Cameroonian government and security forces have taken action towards SCNC members and Anglophones. It's a complete rise and a complete change as to what we saw before. And it's understandable that in the early 2000s, SCNC was seen as an illegal organization, and the activity was seen as unlawful and illegal, and individuals were arrested. But now, people are not only being arrested, people are being killed, they're being tortured, they're being detained. All Anglophones have to go through checkpoints. These regions are now under military control, completely different.
Your point, I understand your point, but right there you said they're just being arrested. There was evidence of arrest and, even torture and detention before. I think your point is that whatever there was before, it's escalated, significantly, to the point that it's a changed conditions. But at least from my review of the record, it seemed like it would be hard to say that in the early 2000s there weren't allegations of torture or wrongful detention.
You're correct, Your Honor. Yes, there were in the early 2000s allegations of arrest, torture, detainment. But we also see in the record where SCNC members that were arrested, a majority of those were released after a few hours or after a few days. And while we do see numbers of individuals who were tortured, detained, of course, there are reports of individuals being killed. We don't see the numbers that we see now. The numbers are now staggering, where we're seeing hundreds and thousands of individuals being arrested, disappearing. We see the rape and sexual abuse of individuals in these regions. We're seeing Anglophones being taken out of their homes being burned to the ground. It's a complete change as to what was being done by the government security forces in the early 2000s to what the government is doing now. It's a complete attack on these regions. And for that reason, we do ask that the court allow and grant Ms. Anago's petition for review and remand to the lower courts.
I want to return to my more technical question, and I understand your other argument, but I'm looking at 1229A-C7, and it says, an alien may file one motion to reopen proceedings under this section, except that this limitation shall not apply so as to prevent the filing of one motion to reopen described in subparagraph C4. And C4 talks about battered spouses, children, and parents. So there is no exception to the one petition, and you're now filing your second petition to reopen.
Yes, we are filing our second.
And so the question is, how can you get around the statute that says you can only file one?
Well, we believe that the statute, when we read the statute for a motion to reopen under INA 240C7C, it indicates that if there is a change in country conditions,
That's a deadline. That's under the deadline. That's a different section altogether. And it says there that a motion to reopen has to be filed in 90 days. And it has to be filed in 90 days except with respect to country conditions.
yes,
That's under a C. But
Yes,
I'm
sir.
looking under A. It says an alien will file one motion to reopen. And there are no exceptions except for battered spouses, children, and parents.
well, we do understand that that's what it indicates in the statute, but we also believe that the regulations provide us additional support in order for us to file a second motion to reopen. And the reason is because
Well, how can the regulations say that if the statute says one?
this is what these are the regulations that have.
Well, the Fifth Circuit concluded that they couldn't. I mean,
Yes,
the Fifth Circuit said you can't get two petitions. You don't get two cracks. The statute gives you one crack to reopen.
Right.
And there's no exceptions applicable here.
Yes, Your Honor. I understand what the statute says, and I understand what the Fifth Circuit says. We don't have that here in the Fourth Circuit, and so our
Well, it's not in the Fourth Circuit. So the question is, how do we read an exception in this statute which says one motion to reopen is allowed? And you've already used that one a time back. This is your second motion to reopen.
Yes, we believe that Ms. Anago is permitted to seek a second motion to reopen because this motion to reopen is based on asylum, specifically changed country conditions, and because there isn't anything in.
You read that in the statute anywhere?
We read that in the regulations, and while that is not in the statute, we believe that the regulations allow for Ms. Anago to seek a second motion to reopen because it's not, under that regulation, she's not limited by time or by numbers. Why? Because if she can demonstrate a material change in country conditions, she can.
Well, I understand that. That gets you out of the 90-day limitation in C. There's a deadline. It says deadline's 90 days. And it says an exception if there's changed country conditions. But there's another limitation in A, which says you only get to file one. And there's no exception to that that's applicable. And okay, I understand. You basically have no answer to the statute, do you?
Well, at this time, Your Honor, we don't see any, decisions from the Fourth Circuit that address this issue, and I could definitely
Okay.
provide additional briefing for that if you would like.
All right, thank you.
Thank you, Your Honor.
Okay, we'll hear Mrs. Kursick.
Thank you, Your Honor. Good morning. May it please the court, Sonia Sarge-Kirksick on behalf of the United States Attorney General. Judge Niemeyer, to your point about the statute, I'll dive right in there. You are correct that the statute only provides for an exception to the time limit for the filing of the motion to reopen, whereas the regulations read in both an exception to the time and the number limitations. The board here did not address that question and did not make its decision based upon that inconsistency. And so if, it would be really up to the board, I believe, to decide that, to deny the petition on those grounds in the first instance. Otherwise, on the merits, the court should deny the petition for review because the board did not abuse its discretion in denying the motion to reopen. The petitioner, in her motion, failed to establish a change in country conditions between the time she first applied for asylum, which was in the aughts, and 2019 when she filed her motion. Notwithstanding that the petitioner failed to present a meaningful comparison between the two situations, the two bodies of evidence that she submitted, the board did engage in such a comparison, looking at both sets of evidence and provided a rational and reasonable explanation for its decision.
Counsel, let's assume I agree with you that that board did that with respect to members of SCNC or the separatist group. The board doesn't seem to have addressed in any reasoned way the claim about change of conditions related to Anglophones generally. It identifies that as a separate group. It says it doesn't meet, there are no change conditions. It says it doesn't, it concludes that it doesn't, that they haven't met their burden there. But while there's extensive discussion about the separatists, there's no discussion about the Anglophones. Now, to be fair to the board, there's no discussion that I read but from the petitioner, from the government about that either. It's like that issue's just kind of there and there's no one's talking about it. Yeah, I asked your colleague that and they said they're kind of considered together. They don't seem to be together to me. But what's the government's position on that?
Well, Your Honor, the board did assume on page 4 of the record that it accepted for purposes of this motion only that the respondent is an Anglophone and is a current member of the SCNC.
Right.
And it looked, I don't see a distinction made between those two groups in terms of the way the court looked at both sets of evidence. It looked at.
But they're different, aren't they? Because one of the things the board says is that, well, there's been no evidence that the government of Cameroon is aware of this particular petitioner or individualized sort of evidence. And I get that. That makes perfect sense to the extent you're making an SCNC claim. It doesn't seem to be relevant at all to, or way less relevant to a claim as an Anglophone generally. Now, you're an Anglophone, you have identifying characteristics. It doesn't matter, to have that individual sort of thing. Now, I'm making arguments the petitioner didn't make, but, I'm just, interested why no one's talking about that.
Well, I agree it's a tricky issue because I think there's overlap. Here, as my colleague acknowledged, the board made its decision based solely on a failure to show a change in country conditions. Now, it also discussed this evidence regarding targeting of the petitioner in particular. However, I think there it was trying to make a distinction between the adverse credibility finding regarding the past activities and then the assumption that it was making going forward that we're going to assume for purposes of this motion that the petitioner does not need to overcome the adverse credibility finding as they would as they would if had that not been assumed away. And so what the board looked at and what the evidence showed was targeting of SCNC activists and Anglophone activists, and it worked with what it had. And the case that was presented in the motion was that, the case that the petitioner presented in her motion to the board at AR 15 referenced in the aughts a simmering but largely quiet tension between two peoples. And by the way, back then the petitioner also submitted a claim based on her Anglophone nationality. And here the board did not decide that, she had failed to present a prima facie case, did not decide that issue. And so I think that's where the overlap comes in.
Well, let me ask you this. The board can and does look at reports of conditions. And, the Washington Post in 2019 talked about 500,000 people have been displaced. The number of people fleeing to Nigeria increased from 7,500 in 2016 to 35,000 in 2019. And then you have these other reports that, the way I read them, they say that there's a real change in conditions in Cameroon.
Well, Your Honor, again, the petitioner was within the board was within its discretion to find that conditions were bad then and that they were bad now. The petitioner in her motion to reopen did not grapple with the IJ's fact findings that there was, horrific conditions back in the aughts. And it was well within its discretion to look at both sets of evidence, and even though it's not required to, it did the digging into the evidence that the petitioner presented, looked at the IJ's findings, and decided that when juxtaposed with the case that the petitioner presented in 2019, if there was any change, it was nothing more than an incremental change of the same conflict and the same tensions that existed. And that is not an abuse of discretion. For instance, the court looked at page 2054 of the record and saw in the 2006 Human Rights Report evidence of deaths of opposition demonstrators, torture of detainees, etc. And I would also add that in the past several years, circuit courts have been confronted with a few of these cases regarding making the similar case, and none of them have decided that there has been a material change, that there was a showing of a material change in conditions, including this court in Takang and I can provide that site, as well as the Ninth Circuit, and which the Takang case we do cite in our brief. In the Ninth Circuit, the Fifth Circuit, and the 10th Circuit, I believe, or the Fifth Circuit, they've all decided that there's been no material change under very similar circumstances, and I can provide those citations in a supplemental letter. Those are all unpublished decisions. If the court has no further questions, the government submits that the petition for review should be denied.
Thank you. Ms. Velasquez?
Thank you, Your Honor. We would like to address the fact that the Board of Immigration Appeals is required to compare the old evidence with the new evidence. And that's what the BIA failed to do. When they were reviewing the old country conditions and comparing that to the new country conditions, there's a focus on the protesters were arrested and detained back then, protesters are being arrested and detained now. That's not the only thing that is occurring in Cameroon. As the Department of State report says, now there's an armed conflict that developed as of late 2016, early 2017. We're seeing death of civilians, disappearances of activists. We're also seeing reports of innocent civilians being killed by security forces in these Anglophone regions. We're also seeing the government entering into the Anglophone region, looking for SCNC members and targeting individuals, whether or not they identify as parts of NCNC or if they're advocating for the secession of these Anglophone regions. The Human Rights Watch report that starts on page 249 of the administrative record also indicates that starting in late 2017, the Cameroonian government used live ammunition against protesters and demonstrators, and that the president
Let me ask you this, is the issue, the board conducted the same analysis that you're talking about. And the question is this a question of fact, or is this a question of law? What is our standard of review? Because it seems to me that you look at two country reports and you compare them, and you're making a determination as a factual matter whether one is simply an incremental increase in the same conditions or is materially different. And they came to the former conclusion. Now, what is our standard for reviewing that?
Right, so we need to, when we review a decision for the Board of Immigration Appeals, it's specifically in cases where a petitioner is seeking reopening based on changed country conditions, the board is required to compare old evidence and
I
new
understand, they
evidence,
made
yes.
the comparison.
And
The
so-
question is, what is our standard?
Our-
They made the comparison and they reached a conclusion. You're challenging that conclusion, and my question is, what is our standard on that?
Right, so we need to determine, did the Board of Immigration Appeals abuse their discretion when coming to that determination, when making that comparison? Our argument is that they did.
Is it a factual finding?
So, yes, Your Honor, it is a factual finding.
All right,
because
and
they're
so we
comparing
defer
facts.
extensively to factual findings. We don't substitute our own for those, right?
Yes, Your Honor. However, what we see here is that the board didn't review all of the evidence, and it's clear because they're only mentioning specific parts of the record. When you take the record as a whole, it's very clear that the conditions have changed in Cameroon, and that's why we asked for the case to be remanded. Thank you.
Thank you. All right, I don't know if you were in the courtroom, but I wanted to just reiterate that we would normally come down now and greet you and thank you for your arguments and welcome you to the Fourth Circuit. That's our practice, and so because of our protocol, we have to do it now remotely, and so we do thank you for your arguments and wish you well. And when you come back to the Fourth Circuit, I hope we come down and shake your hand and greet you personally. All right, we'll take a short recess.
The Honorable Court will take a brief recess. Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
All right, be seated, please. All right, next case we'll take is Sanchez Diaz versus Garland and Mr. Canari.
Good morning, Your Honors. My name is Abdul Kanar, and I represent the petitioner in this case. Your Honors, Hilda Sanchez has established that her imputed political opinion was at least one central reason for her persecution. She has also established that the government of El Salvador was unable and unwilling to protect her. As a result, she is presumed to have a well-funded education. Because of that, the burden shifts to the government to prove fundamental changes in the circumstances or in the alternative, internal relocation. In this case, the government was unable to prove either. And as a result, and because of it, we ask this court to reverse the decision of the BIA and of the IJ. Here, the facts are as follows. In November of 2013, Mr. Sanchez came home and found an MS-13 insignia on the outside wall of her house. And when she saw that, she was very mad. As a religious person, she said, I will not stand for this. If I let this one go, it means I am for the gang and I am against God. And she called upon her brother-in-law to help her clean up the wall. And as soon as she did that, a couple of days later, 2 MS-13 gang members showed up and said, first of all, 2 days later they showed up. Second, they parked their car right there by the wall. And third, they were pointing at the wall when they were talking to her. And they said to her, what we do, nobody gets it undone. Then they threatened her with her life.
So counsel, considering those facts, the immigration judge and the board affirmed that may have reflected, some, disrespect of the MS-13 gang, but it didn't rise to the level of a political opinion. It wasn't part of any organized political activity. I understand the arguments both ways on that. I'm really not, we could debate that, but isn't the fundamental point whether or not the agency, if it requests remand, when Congress has given the agency, the responsibility for the immigration issues like this, whether we're, whether we, let them remand the case for reconsideration if they think there's additional work that could be done. Both the Supreme Court and the D.C. Circuit and have cases that talk about that. It seems like it's a pretty broad deference that we provide for that. Why wouldn't we do that?
2 reasons, or more than 2 reasons, Your Honor. In general, when the board errs, this court should remand. But this is not an invariable rule, Your Honor. And here we have undisputed facts in this case. Undisputed.
Yeah, but we're not fact finders. And we never find facts or weigh facts. What the question is, the facts and the significance of the facts and the context of the facts are matters for the agency. And we give them enormous deference on their fact finding and overrule them. But here we have an agency said they don't want to defend. They want it to go back, and it gives you a chance to make the points that you have made, and you can even tell them, you can put more evidence in, I suppose, if they request. If we get granted just a remand, because both parties requested remand, shouldn't we review it then and not now?
One legal answer and one human answer, Your Honor. In this case, when a board arbitrarily ignores substantial evidence. This court has reversed. Look at Tassie versus Holder. This court exactly held the same way. And also in this case, the Board of Immigration Appeals has found there was no nexus, and they were wrong. In Perez Vasquez versus Garland, this court has reversed the decision of the Board of Immigration Appeals. Now remand.
Well, without getting too far in all of it, this case has got some gaps in it too. There's no request to go to the government, to the police, and her motives were basically not were aesthetic, and she didn't want to be associated with the gang. And the question is how that was taken. These are all nuanced facts, and I don't think we gain much in going into a fractured record or a thin record and then also remand when both parties have requested a remand.
But here,
You want us to find error and remand to have a do-over, right?
Your Honor, there's no fractured record in this case. In matter of essay, this is a Board of Immigration Appeals decision in 1997. You do not need to go to the police if it's futile or if it's subject to further violence.
Well, the evidence of futility was almost nil.
But but that's what the Board of Immigration Appeals and the IJ said. They said, oh, you didn't go to the court, but it is not a requirement. In Oriana v. Barr, from this court, you don't need to go to the court if there is.
No, you don't need to, but you're reading that in a too narrow a context. It always is a context because you have to have governmental persecution, and so the question is how you get there, and you can't just leave it open. You've got to supply some facts, and we have said the failure to call police alone is not sufficient, but that doesn't answer the question.
But here, Your Honor, they failed to take into account the broader political context of gang violence in El Salvador. We have submitted substantial evidence that shows, number one.
I mean, the question is whether they acted in response to her because she was a member of some organization, or was it individualized? In other words, she was not hostile to took a political position against them. She did not want to be associated with them, and for that and aesthetic purposes, she wiped it off.
She did it because it was against her value. She did it because she wanted to take a stand against the gang, Your Honor. That is the reason why she did it, Your Honor. And here, country condition evidence are highly probative evidence in a foreign country. And here it says the government of El Salvador was not effective in combating violence. And the gang members control their neighbor. They control movement in the neighborhood. What else do we want, Your Honor? This poor lady couldn't go to the police. It was impossible at that time, Your Honor, to get any kind of help from the police. Therefore, she didn't go. And substantial evidence support that. I believe, Your Honor, the Department of Justice should just confess error. There's nothing wrong with that. This poor lady has been in proceeding since 2014, Your Honor, about over 8 years now. Over 8 years. She was able to prove, she was credible. She proved a nexus in imputed political opinion. And she was able to show, and the government in their brief, all they argued was remand, Your Honor. They were not pretty much even now going against our point. They're pretty much arguing remand. Why couldn't they just confess to error? They should just confess error. This has been going on for 9 years. 9 years, justice delay is justice denied, Your Honor. And there are facts in this case that prove our client's case. Simple. They just would not confess to error. Here, nexus has been established, as per Vasquez v. Barr, because an asylum applicant need not show conclusively what persecution occurred in the past or likely to occur in the future. However, it must produce evidence to show that harm was motivated, at least in part, by an imputed and actual protected category. Here she has. She took against control of the gang in her neighborhood. And in Hernandez Chacon versus Barr from the Second Circuit, they held exactly the same way. Taking a stand is an imputed political opinion. That's what she did in this case. So it's undisputed record here in this case, Your Honor, that she was against the gang. Forget about the political opinion because that's not what we're arguing. Imputed is from the perspective of the gang. That's what they said. They said, what we do, nobody gets it undone. That's the record, Your Honor. So sending this back to the BIA and to the IJ.
Well, the record's more complete. I mean, you know, it's not a good to cherry pick the evidence. That she said exactly what you said, but it was also she started paying rent to them or fees or extortion payments. There's no evidence that they painted their name back on the wall. The wall was cleaned, and so she went on and started making payments. And that lasted for, I don't know, months. It's all a little more nuanced than that.
Your Honor, I respectfully disagree. It's not nuanced. She had to pay the money because she was asked to do so. She was going to get killed if she didn't pay. So she paid $500 and she was required to do so. And then
So everybody in El Salvador who pays rent to gang members, extortion members, can petition for asylum just for that, on that basis?
Your Honor, we never...
My question is, if you just pay rent or pay an extortionary fee to a gang that controls the area, is that enough for asylum?
Absolutely not. But that's not the facts of this case, Your Honor.
No.
That is not the facts of this case. Absolutely not. And by the way, paying extortion money is not mutually exclusive with an imputed political opinion claim. It is not, Your Honor. It is not. And the government knows that. It is not mutually exclusive. And that's not the point. The point is not about extortion, payment of extortion at all here. It was her imputed political opinion claim in this case. And the government failed to rebut.
Well, she was apparently living in some kind of peace with the gang after she cleaned it. And they came in and said, you don't undo what we did, but they didn't make her paint it back on or write back on the wall. They achieved a relationship where she paid rent and they left her alone.
How can you, Your Honor, she's paying rent. She was told if you don't pay rent, we're going to kill you. How is that
Well, that's
peaceful?
extortion.
How is that peaceful, Your Honor? That can't be peaceful if they're threatening you with death. That's not peaceful, Your Honor. And then after that, she had to pay monthly rent, Your Honor. So how is that peaceful? That's not peace. That is extortion. That is threat. That is persecution, Your Honor. So in this case...
Is that persecution because of her political position, or is that persecution just to, like the mafia, is to collect money?
No, it was persecution on account of her imputed political opinion for taking a stand against MS-13 gang. As a retribution, she was asked to pay rent. So it was 2 in 1, just like in Cordova versus Holder. Just because you have one does not exclude the other. So you could have 2, and that is fine. But in this case, there's no denial. Even the BIA said she disrespected the gang, and that is the reason why she had to pay. The disagreement with the BIA was they don't think that it goes far as to showing imputed political opinion, and we disagree because it does. Because the BIA even disagree with the IJ. Your Honor, I'm sorry, my time is up.
Okay, thank you. I think you have some rebuttal, yes. All right, Ms. Leach.
May it please the court, Abigail Leach for the Attorney General. The court should remand the instant case back to the board for further clarification and analysis of its determinations and also to address this court's intervening case precedent in the first instance. As an initial matter, remand is warranted for the board to provide...
Can you move your speaker over a microphone or just speak up a little bit?
Better?
Yeah,
Is that better? Should I be...
Yeah, we're right across the room from you.
Sorry about
Thank
that.
you.
Remand is warranted for the board to provide further clarification and analysis of its determination that the erasure of the gang graffiti was not a political opinion, and also for clarification that the gang did not impute a political opinion upon the petitioner. Where the record is unclear on the basis where the agency has made a finding, the appropriate remedy is to remand for further analysis and consideration. In so doing, the board could be more explicit in the evidence it considers and also consider this court's case law on the relevant issues. Similarly, because it's unclear how the board analyzed and reviewed the nexus family-based claim, the court should remand for further clarification on the analysis and also for consideration of intervening case law, including Perez-Vasquez and Toledo-Vasquez. Finally, petitioner concedes in his opening brief that remand is warranted for further analysis of the protection under CAT claim. If there's no questions, the government rests on the arguments made in its brief.
All right, thank you. All right, Mr. Canary?
Sir, let me ask you two questions.
Sure.
Exactly what are you asking us to do? Is that to reverse and remand to the BIA with instructions to rule in her favor? That's the first question. And the second question, are you abandoning your argument about the relationship? She's being persecuted because of the relationship with her mother.
I'm sorry, I didn't hear the last.
That she's being persecuted by her relationship with her mother. Are you abandoning that claim?
To answer to your first question, we are asking this court to reverse the decision of the BIA. Yes, we are, because we believe that we have proven that her imputed political opinion and her family membership were the reasons why she was persecuted. Number two, we're not abandoning family membership because family membership constitutes a particular social group where there is a sufficiently strong and discernible bond between family members such that the family relationship becomes the foreseeable basis for persecution. And that's what we have in this case, Your Honor. Here, the mother was threatened. The two sisters were threatened with death. They ran to the United States. They have a case pending. The last one, Rosalinda, also was threatened and was paying rent. And they asked her, by the way, where's your sister? We want all of you. They threatened to kidnap, rape, and kill them. And all three are in the United States. And the mother is in hiding. And the cousin has been killed. Your Honor, this is a typical family membership as well. And the BI missed that. And the IJ missed that as well. So here in this case, Your Honor, remand is not warranted. Reversal is. Because
We have to find facts contrary to the factual findings, and we're not in a position to do that. We don't find facts. If we find an insufficient analysis, that they didn't take into account certain facts, as you argue, we send it back to let them do that. But we're not a fact finder, and the standard for reversing on facts is one of the highest we have, isn't it?
But the facts, Your Honor, the legal analysis, the legal conclusion is based on the facts. They completely ignore the facts here. So when you
Well, then your remand should be, don't ignore the facts.
But Your Honor, how long are we going to do this? Another 9 years, Your Honor? Justice denies.
Well, that's another issue, and that wasn't raised as to, I mean, these processes are not.
9 years.
I don't know why it's 9 years, what the sequence was. How come it was 9 years?
First of all,
She entered without permission?
That is correct.
Okay, without examination? And when was she notified by the agency?
2014.
To appear?
Yes.
And then what happened?
She went to court, and the IJ denied the case. We appealed to the BIA dismissed, and then we appealed it. So it took that long. It was not our fault that it took this long. It's just this is the process. So we're gonna remand again to the board, to the same
Is she in the United States now?
Yes, she is.
Well, why is she complaining about those 9 years? She's lived here for 9 years.
No, that's not the point. The point is.
No, the point is you said that she's as if, sure, it needs to be resolved, but the process has been followed. Nobody has criticized the time delays and so forth. I haven't seen anybody lay out that somebody delayed or did it inappropriately, number one. Number two, based on what the agency decided, she's ordered to go back. And so it seems to me, you shouldn't be arguing time.
Your Honor, we are not asking anything differently than this court has done in the past. Perez Vasquez, Hernandez Cartagena, Avalos Lagos, Zavaleta Policiano, Oliva versus Lynch, Hernandez Avalos. We're not asking anything differently than this court already did before. So this court has reversed the decision of the BIA when they held that the applicant has not shown nexus, has not shown a particular social group. We're not asking anything differently, Your Honor. So by sending it back to the BIA for further analysis and explanation, Perez Vasquez did not change the law, did not articulate any new precedent. As a matter of fact, Perez Vasquez admonished the BIA for engaging in improper and excessively narrow interpretation of the nexus requirement. That's what this court held. So why sending it back again for remand? They should reverse the decision of the BIA. And with that, the court will, we will find a solution to this matter, Your Honor.
And what if we find the evidence ambiguous?
I hope this court doesn't find.
Well, I understand that's your position, but the reason she gave for taking down that sign didn't sound like opposition to the political opposition. It sounded to me like she did not want to be associated with a gang because she was Christian, and she wanted aesthetically not to have that on her shop. But that was her testimony. Now, the question is, you can explain the context more, but I'm just saying that could be ambiguous.
But that's, Your Honor, that's what the testimony says. It shows, she says right there, I was taking a stand against them. Going, not erasing the sign was, for me, it's like being against God. That's what she said in the record. That's what the record indicates. What you're saying right now, Your Honor, is not in the record. That's what she said. And that's what unless we require a confession now from the MS-13 gang members or the perpetrators, because I don't know what else can this petitioner do. That's what the record shows, Your Honor. So we're asking this court to reverse the decision of the BIA and not to remand for further analysis and explanation, Your Honor.
All right,
Thank you, Your Honor.
All right, we would come down and greet counsel in the ordinary course, but we're following the protocol still. When the next time you come to court, I'm quite sure we'll come down and shake your hands and probably try to remember this proceeding too. Thank you very much. We'll proceed on to the next case. And I guess, Ms. Taylor, you're first.
Thank you, Your Honors, and may it please the Court. I'm Elena Taylor, representing petitioners Ms. Lucinda Larios Vargas and her minor daughter, KAVL. This case comes before the Court on a petition for review from the Board of Immigration Appeals decision denying Ms. Larios Vargas' applications for asylum, withholding of removal, and protection under the Convention Against Torture. The primary issues in this case are, first, whether the Board of Immigration Appeals committed legal error in holding Ms. Larios Vargas to a per se police reporting requirement in analyzing her application for asylum and whether the government of Honduras was unable and unwilling to protect her. The second issue in this case is whether the immigration judge and the Board of Immigration Appeals erred in analyzing Ms. Larios Vargas's application for protection under the Convention Against Torture, as they did not analyze all factors required by the regulations. And finally, the third issue in this case is whether the Board of Immigration Appeals erred in applying a clear error standard of review when this court has determined that acquiescence is a mixed question of law and fact. Turning to the first issue in this case, whether an applicant has established that the government of their country is unable or unwilling to protect them, this court has never applied a per se reporting requirement. An applicant is not required to report the harm that they've experienced to the police in their country if doing so would be futile or would subject them to further abuse. In this case, the immigration judge at JA 81 through 82 did require a per se reporting requirement. And the Board of Immigration Appeals at JA 4 has also held Ms. Larios Vargas to this requirement. They say, and I quote, "The immigration judge acknowledged that the government of Honduras has severe issues controlling crime and gangs. However, in light of the respondent's failure to report the threats to the police, the immigration judge found that she did not establish that the government of Honduras was unable or unwilling to protect her," end quote. In this decision, by saying this, the board held Ms. Larios Vargas to a per se police reporting requirement to establish that the government of Honduras was unable or unwilling to protect her. And this is a legal error.
I don't know if that's per se. They found it because that's the only evidence in the case, but it seems to me it depends on the context, what the reason was. I mean, in this case, as I understand it, she called 4 times on the day of the event. Nobody answered the phone for the first 3 times, and on the 4th time, she reached the police department in another city, and she never followed up after that. So those are the facts of this case, and she must have assumed that the police could have done something or would do something. But I think per se is the mere fact that somebody didn't call automatically, it establishes a particular point. In this case, that's the evidence, and there's no explanation that it would be futile. There's no explanation that the police have been called many times and they didn't ever came and that type of thing. That's usually the context.
Your Honor, we disagree. I mean, my reading of the
What
board...
are you disagreeing with? What?
With the reading of the Board of Immigration Appeals decision that they did...
Well, what evidence did your client offer about the government's role? I mean, this is a very thin record. She testified, I read her whole testimony. It's only a few pages, and there's no other evidence in there except the country conditions.
Well, Your Honor, in her testimony, she stated that she called the police 3 times herself, had a neighbor call for her, and they didn't get through either. And then the 4th time that Ms. Larios Vargas called, she did actually get through to the police, and she testified credibly that she was calling the correct police for her department, and they told her that they were not the police for her department. And as Ms. Larios Vargas testified credibly that she was calling the correct phone number for where she lived, and there's no disputing that, and the immigration judge found her credible, it seems that the police that she did reach lied to her and pretended to be the police for a different area rather than admitting that they could help her. This demonstrates that the police were unable or unwilling to protect her and that continuing to seek police protection would be futile. However...
So, counsel, I grant you that there's not a lot of explanation on this issue, but to follow up on Judge Niemeyer's point, if the board were to have said, or the IJ were to have said that, look, the petitioner submitted country conditions, those alone are not sufficient under our law. There was this testimony about several calls, but we can't say that rises to the level of futility. I mean, that might be something that it's permitted to do. Our problem is they didn't really say that. The only information we have is about that's stated is about not reporting. So it's kind of a weird. They never say this is a per se rule. You know, the IJ seems to kind of grapple with it a little bit, but, and I understand the argument, but, you know, there's also, you know, not a whole lot of evidence on futility here.
Well, Your Honor, I do think that the Board of Immigration Appeals did sort of apply a per se rule just in their statement, but the country conditions evidence further supports Ms. Larios Vargas's testimony that the government of Honduras was unable and unwilling to protect her. And there's
Those country conditions, I think, talk about, you know, that, you know, real problems, you know, that the government faces in some of these countries. I'm not trying to belittle them in any way, shape, or form. But it also talks about efforts that the countries have made to attempt to resist that. So they tend to be ambiguous, or at least cut to some extent both ways. You know, I think your point's a good one. When you read this, there's references both with the IJ and the BIA talking about the failure to your report. I think you got a good point there, and the other things aren't really explained well. It's just, yeah, I'm not sure that if we were looking at the evidence of futility alone, or, you know, or future risk, it's a lot less than we typically see.
Well, Your Honor, I think that the record as a whole, while there is certain points of the record that demonstrate that the government is somewhat trying to make efforts to better the situation, just because the government is making efforts to better the situation doesn't mean that these efforts are effective. And all of the evidence in the record demonstrates that the efforts that they're making is not effective. However, you know, looking at the Board of Immigration Appeals analysis of futility, it's very light, and they don't analyze further abuse at all. And Ms. Larios Vargas'
Their futility analysis actually doesn't make any sense.
No, Your Honor.
I mean, they say it's futile because they might have heard from someone else. So it's not just light, it's incomprehensible.
Yes, Your Honor, we agree. And I think that could be a reason to remand this case. The Board of Immigration Appeals did not properly analyze the questions of futility, and they didn't analyze the questions of subjected to further abuse at all, despite Ms. Larios Vargas' testimony that after she called the police, about a week later, I believe, a gang member went up to her and told her that because she called the police, he would kill her. This kind of goes to show that there's evidence that she would be subjected to further abuse by filing a written report if merely calling the police was sufficient for the gang member to threaten to kill her once more.
What particular social group are you trying to put her in?
Well, Your Honor, in this case, the Board of Immigration Appeals did not address the particular social group or any protected ground. However, I believe that the particular social groups presented at the trial level had to do with, I believe women was one of them. I'm sorry, I don't quite recall all of the ones that were presented, but I do know the Board of Immigration Appeals did not address the protected grounds in its decision, relying only on the government inability or unwillingness to protect Ms. Larios Vargas, though the immigration judge did state that she would have a reasonable fear of future persecution. So I do know at least that much about the immigration judge's underlying decision. Turning to the other issues in this case, if I may, as we have two issues regarding the Board of Immigration Appeals analysis of Ms. Larios Vargas' application for protection under the Convention Against Torture. First, the immigration judge's decision did not consider all factors required by the regulations. At JA 84, the immigration judge analyzed Ms. Larios Vargas' application for protection under the Convention Against Torture and addressed only whether or not Ms. Larios Vargas was subjected to past torture. However, the regulations clearly outline 4 factors that an immigration judge should consider. In fact, the regulations say that they shall consider this. These factors are whether the applicant was subjected to past torture, the ability to relocate within the country of torture, evidence.
But counsel, if there's a finding that there is not been torture and you haven't met your burden of future torture, the relocation is only if there's torture in the first place. So that I mean, sure it says all things, but it doesn't. You don't get to the relocation issue unless you got torture where you lived in the first place.
Respectfully, Your Honor, there is no requirement for past torture. It's a future-looking analysis, and the immigration judge only considered past torture.
Well, maybe they talked about that, but I think they found you had not met your burden of showing future torture with respect. Yeah, I think they combined it with the acquiescence. So maybe you're right in the sense that it was combined into one sentence. But I guess my point on the relocation is what I'm getting at, is that relocation, you don't need to relocate if you haven't shown the risk of torture if you return in the first place.
I understand that, Your Honor, but in analyzing whether an applicant would be subjected to future torture, the immigration judge is meant to consider all four factors, and the immigration judge merely considered past torture rather than all four factors. And determining whether the applicant would be subjected to torture, the immigration judge is required to consider all four. And this is at 8 CFR 1208.16C. That outlines these factors and states that the immigration judge shall consider these factors, but the immigration judge merely considered the first factor and found that that would be sufficient to find the applicant would not be subjected to future torture. As a result, the Board of Immigration Appeals as well affirmed this finding, and this is a legal error to only analyze one prong of a four-part framework, requiring remand. And then reaching my third and final issue, as to the applicant's application for protection under the Convention Against Torture. The Board of Immigration Appeals reviewed the immigration judge's decision as to government acquiescence for clear error. In Cruz-Quintanilla versus Whitaker, this court has determined that government acquiescence is a mixed question of law and fact. What would happen or what did happen is a factual question, and whether that's sufficient to show that the government or a public official would consent to or acquiesce to torture is a question of law. And in this decision, the immigration judge found that there would be no government acquiescence, and the Board of Immigration Appeals only reviewed this for clear error without acknowledging that this involves a question of law as well.
Counsel, can I interrupt you? I'm having, just looking back at the IJ at J84, the immigration judge says that, the court does not find it is more likely than not that she would be tortured or killed upon return to Honduras. And so they did make that finding. And then they said, even if there is a reasonable fear of future torture, the respondent has not shown that it would be with the consent or acquiescence of the government official. You said they didn't consider it, but as I read it, they did.
Well, Your Honor, the immigration judge did consider whether or not Ms. Larios Vargas would be subjected to torture, but in doing so did not address every part of the analysis that she was supposed to address. She addressed the past torture and the government acquiescence, but 8 CFR 1208.16C requires that an adjudicator consider four factors, and she considered only past torture and government acquiescence.
She
and
didn't just consider past torture. She said it wouldn't be tortured or killed upon return. That's future.
Yes, Your Honor, but that doesn't address the other three factors. It doesn't address the relocation. It doesn't address the gross mass human rights violations in the country or other relevant evidence that the adjudicator is supposed to consider.
Why would you have to consider those if you found if you find the first ones? It wouldn't lead to this is what Judge Quattlebaum just said earlier. It wouldn't lead to a requirement to analyze going someplace else because there was no risk even if she went back to her home space.
Well, Your Honor, to come to this conclusion,
it sounds like you're asking for a mechanical application of regulations of factors that are relevant. In other words, if you find that there's likelihood of torture or there was past torture and there is going to be future torture, can that be obviated by going to another portion of the country? But if you don't reach that, answer the first question right, you'd never have to get to the second one. And they did consider country conditions. It's sort of, they don't tick the boxes, then you're saying there's error. But in substance, they addressed what the statute requires that be addressed. That is under CAT, you have to find some state-sponsored torture.
Your Honor, my time has expired. May I briefly answer?
Yes, sure.
Thank you, Your Honor. I'm not asking that this court apply a strict requirement for what an immigration judge is supposed to consider, but this court's law has held that an immigration judge is supposed to consider all evidence in a case. And to fail to analyze three key parts of a legal framework.
Yeah, but you got to start with facts. And the facts, this woman testified fairly generally. She speculated about a couple of things. Her testimony is only over a few pages, and there are no other witnesses. And all we have is the state conditions. And so that's the whole case. Now you want, I don't know what you want, talk about various possibilities that could have happened, or?
No, Your Honor. What we want is for the adjudicators to consider all prongs of a legal framework that is binding on the agency, and the agency only considered the first prong.
Okay.
Thank you, Your Honor.
Yeah, thank you. All right, we'll hear Mr. Nardi.
Good morning, Your Honors. May it please the court. Anthony Nardi on behalf of the respondent, Attorney General Garland. Excuse me, Your Honor. Respondent has two main points in this case. First, the petitioner failed to demonstrate that it would be futile or subject her to further abuse to continue to pursue the protective process. And accordingly, under this court's precedent in Orlando v. Barr, she's abandoned the protective process and cannot show that the government of Honduras would be unable or unwilling to protect her. Second, with respect to cat protection, the petitioner also failed to demonstrate that it is more likely than not that she would be subject to torture upon removal by or with the consent or acquiescence of the Honduran government. And for those two reasons, the court should deny the petition for review.
Counsel, if I could focus on your first point there, both the IJ and the BIA, give extensive discussion about the failure to report. And even though, and I'm not seeing where they've said there's any other reason that they're denying the claim other than the failure to report. Now, the BIA does talk about our case with futility, and so it seems to maybe recognize this issue, but or futility and risk of future harm. But the only discussion it gives of it is, I probably shouldn't have said it the exact way I said before, but it's talking about futility that in a way that really doesn't seem to deal with futility and doesn't address the risk of harm at all. So where do we get anything besides the failure to report in either the IJ decision or the BIA decision?
Yes, Your Honor. I think in the board's decision, they do note that there are these two exceptions to the reporting requirement after they cite Orellana.
Right.
And I think it comes from the fact that in many of this court's and the Ninth Circuit's decisions looking at this framework of futility and further abuse, these two elements oftentimes get conflated, particularly when discussing futility and the collaboration between criminals and the law enforcement. Particularly in this court's decision in Orlando v. Barr, you noted that even though it was framed initially in futility language, it would also have subjected the petitioner to further abuse because the police showing up were leading to more violence. Additionally, in this court's decision in Portillo-Flores, where factually there, the petitioner was being persecuted because the gangs were searching for his sister. When the police showed up at his mother's house, the petitioner's mother saw that the actual gang members who were searching for petitioner were with the gang members. And there the court, while not holding, asserted that was strong evidence of futility, but also that would lead to further abuse because while it was futile to go to the police that were directly working with the gangs, it would also lead to further abuse because if you did contact those police officers, they would then clearly tell the gang members, which would also lead to further abuse. And so while I agree that perhaps that first line of the board's decision when looking at the two alternatives is perhaps overstated. I think the rest of the board's analysis shows that they did and were thinking about these two elements.
Well, actually, the rest of it is, the only thing they talk about is the failure to report. After that, don't they?
Yes, I was sorry, Your Honor. I was stating that after the sentence starting first on page 4 in the fourth paragraph, then they go on to look to the futile and the further abuse.
Right, that we cannot, the citation in the we cannot language?
Yes, Your Honor.
Okay.
And just, I think to move to further abuse, I think the agency properly considered the evidence that is in the record here. That petitioner stated that her family had previously given information about her to the gangs unprompted. She also testified that she was not entirely sure how the individual gang member who was trying to persecute her had gotten knowledge that she'd called the police, though she stated that it could have come from her family as they had priorly given information, or as when she made that fourth phone call, she was no longer locked inside of her house. She was outside, and there were people around who she was not sure, but she said might have been gang members themselves, and that could have been another avenue of how the gang members learned that she had called the police. And I think for that reason, it was reasonable for the board to determine that she'd failed to carry her burden, as it is the burden of the petitioner to show that it would be futile or subject to her further abuse in that context. And just to also discuss a point my colleague raised regarding the call to the police and whether or not the police were lying, I think two things can be true at once. This was only raised twice in the testimony. The first time on direct exam, she stated that, the petitioner stated, I called the police 3 times and they didn't answer. My neighbors called them. When I called the 4th time, they told me they were not the police from my area and that I was calling the police from San Pedro Sula. She was asked, did you call any other police? She stated no. And then on cross-examination, the only information we gained about that is the question was, when you tried to call the police during the incident, were you calling the number for police in San Pedro Sula? And she stated, I called the one from Progreso Yoro, where I'm from. And then she was asked, were you calling the wrong number? And she stated, I dialed the same number, and they told me they were not police from the area where I lived. I think two things can be true at the same time. I think the petitioner did credibly testify, but I do not think those statements necessitate the finding or logically follows that it was therefore the police were lying to her about where they were from. She might have simply been mistaken, but that does not show any light on the credibility of her as a witness. I think for those reasons, Your Honors, the agency properly put the burden on petitioner to show that it would have been futile or subject to further abuse, and concluded that she had not met that burden. Accordingly, she could not meet the standard for unable or unwilling. And moving to my second point with regard to cat protection, here the agency properly considered all of the relevant factors. First, the IJ found that she had not.
Can I go back to you? I'm sorry. We'll give you time on the cat, but what I want to think about is how we look at the finding regarding government consent and control. I mean, the BA found that, and I think our job then is to look at that, and we would reverse if it was a legal error, and we would reverse if there's no substantial evidence of the finding, of the conclusion. I think you might have a decent argument that there's no it'd be hard for us to say there's no substantial evidence given the thinness of the record that we've talked about before. The real question is whether there's a legal error, and I think the real question is whether there's a legal error there. And that's what I think your colleague is arguing, and there's some basis for it. I mean, I guess your position is there's no legal error at the BIA level, at least, because they've recognized the exceptions. Even if they didn't articulate it the best way, there's substantial evidence that doesn't compel the opposite result.
Yes, Your Honor.
All right, you can talk about cat. I'm sorry to cut you off there.
So just going back to cat, The IJ initially started by stating that the petitioner had not suffered past torture, which is one of the elements under the regulations. She then went on to find that the petitioner, assuming and incorporating the country conditions evidence into her analysis, the IJ found that the future threats, the two unfulfilled threats, were too speculative to constitute a clear probability of future torture. And in particular, the IJ did note the country conditions evidence, which is outlined at pages 73 and 74 of the record, and did state that there was a general existence of pattern or practice of human rights abuses, but that without more evidence, as this court has found in both Singh and Lizama, without more evidence, those country conditions alone cannot uphold a CAT denial. And unless the court has any further questions regarding those two.
All right. Thank you, Mr. Nard.
Thank you.
Ms. Taylor?
Thank you, Your Honor. So I'd like to make a few points on rebuttal. First, I would point out that the Board of Immigration Appeals, even when considering whether it would be futile for Ms. Larios Vargas to file a report, as we've discussed, there's issues in their analysis, but they also went beyond their scope of authority by engaging in fact-finding when they discuss whether filing a police report would be futile. In this case, the immigration judge didn't address futility at all, and futility would involve a question of fact. It looks at what would happen and then whether that rises to the level of futility, and the Board of Immigration Appeals had to address both in the first instance because the immigration judge did not address it at all, and so the board went beyond its authority to engage in this fact-finding.
Well, wouldn't there have to be some evidence in the record to trigger that kind of finding? In other words, if the record was totally blank about reporting, nothing, nobody asked the question, and the petitioner just didn't say anything about going to the police or the government or futility or anything. What's the IJ and the board supposed to do when there's total absence of evidence?
Well, Your Honor, if there's a total absence of evidence, which I don't believe is present in this case, but in another case where there is no evidence of any reporting to the police, then I would say they still have to at least acknowledge that the standard does not require a police report if there is no evidence of calling the police. But perhaps in that case, the analysis does not have to be as in-depth when there's no evidence of any attempt.
Well, ultimately, it has to be imputed to the state. And usually one way to do that is to make a report or call the police or have the police come or whatever, and they fail to do it. But my question is really when there's an absence of any evidence, there's just a failure of establishing the elements of an asylum claim.
Well, Your Honor, I would say in a case where there's an absence of that and the immigration judge wants to rest on a different prong of the asylum claim, then they can rest
Well, there's
on
no prong because there's no evidence. In other words, you're assessing evidence. And if they, well, all right. I won't press it any further.
Let me follow up, if I might, and exclude from this right now the fact-finding issue that you just talked about. We can deal with that later if need be. But putting that aside, as I was just talking about with your colleague, it seems to me the way we look at this is we look and see whether the BIA made legal error. And I think that's what you've said they've done by imposing a per se requirement of reporting. I think, I'm not asking you to, let's assume we don't think that happened, that they at the BIA level at least acknowledged the legal test, and but there's this question about how they explain futility that might be explainable or it might not be explainable. If we don't think there's legal error, isn't our responsibility to then look at the record ourselves and see whether substantial evidence compels the opposite result?
Yes, Your Honor. That is what we would look to next. If there's no legal error, we look to the facts and look for substantial evidence. And I think substantial evidence is clear in this case. Ms. Larios Vargas made every attempt to report to the police by calling 5 times, one time with the help of a neighbor. If that's not sufficient, then I don't know what is. Plus, the country conditions evidence makes clear that the police and the government of Honduras is unable and unwilling to protect her, and that filing a police report would have been futile and would have subjected her to further abuse. Her credible testimony, I understand my colleague's point, but is that she called the correct police department, and there was no follow-up on cross-examination to further probe that point, and the immigration judge found her testimony credible. So the testimony is that she called the police from her area, and they told her that they were not the police from her area. That is sufficient, plus the country conditions evidence, plus all of this together. The record compels this. And then as to final points on CAT, in Rodriguez-Arias, this court has found that country conditions alone can be sufficient in CAT cases to show certain prongs of it, as for government acquiescence and other things. And in this case, there's plenty of country conditions, but I see my time has expired. Thank you.
Thank you very much. All right, as I've said earlier, we are not going to come down and shake hands, but I want to thank you on behalf of the court and thank you for your arguments and greet you and welcome you back for next time. We'll adjourn court for the day.
The honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.